May it please the court. My name is Stuart Graham, counsel for the defendant Ralph Nesbitt. This appeal presents two issues. First is asserted violations of the defendant's Sixth Amendment rights. The second involves the admission of inconclusive DNA test results. I'll assume the court's familiar with the facts unless you indicate otherwise and proceed to the argument. On the Sixth Amendment issues, the victim made one statement, but she made it twice. That statement was identifying Mr. Nesbitt as her assailant. In Crawford v. Washington, the court held that testimonial out-of-court statements offered for their truth in the absence of the declarant or a prior opportunity for cross-examination would violate the defendant's Sixth Amendment rights.
But let's break this down a little bit. The first statement is this 911 phone call in which she is seeking help after having been stabbed 23 times. She calls the police. Oh, my God, hurry up, help me.
Yes, Your Honor.
What's the problem, ma'am? The defendant just came into my house and tried to kill me. Who came in? Hello, help me. Are you going to answer my questions? Where do you live? Who came in? Ralph Nesbitt. Do you need a rescue? Hello, do you need a rescue? Please hurry. I mean, on and on. She's dying. She's bleeding to death. How does this qualify as testimonial?
Okay. First of all,
and secondly to that question, isn't this answered by our case Galicia?
I don't believe so. Galicia follows Davis v. Washington, and I'll make the distinction that I think pertains here. Initially, I would say, Your Honor, that on her initial statement to the 911 operator, she didn't identify the defendant. It was inaudible.
It doesn't mean she didn't do it. It just means it's inaudible on the tape.
Well, I don't think we can.
It's inaudible, just came in my house and tried to kill me.
But we don't know what she said, and I think it would be inappropriate to assume from an inaudible statement that she
the next question is, who came in? Answer, Ralph Nesbitt.
That's correct. After he asked, what's your address? She gave him the address. He then asked, who came in? She identifies the defendant.
And they ask, is he still there?
Is he still there?
Isn't the 911
that comes somewhat later.
Well, a couple of questions later, but isn't this the kind of emergency contact that we have said just falls out of the testimonial category altogether?
I think it's close, but the distinction was made in Washington v. Davis and again in this court and in Galicia, as Your Honor indicated. That is, there's a distinction between a statement made during or to resolve an ongoing event. Those are non-testimonial, as Davis held. Then there are statements that are made with reference to a past event, describing something that has happened. Those are testimonial. Both those kinds of statements could be in the same 911 call, as the court held in Davis. And the court said, use motions and eliminate to sort out those two statements. It should be noted that in this case, it was the same statement made in the 911 call was the same statement made to Mr. McCure, the neighbor. That is, who did this? The defendant or Mr. Nesbitt. It's the same statement made twice. The purpose of that statement.
Can I interrupt you for a minute?
Yes, Your Honor.
I don't want to take you off your game, but another, in addition to, the Crawford that you're talking about now, a second basis is argued by the Commonwealth as to both statements, and that is their dying declarations. My question is, did Crawford say dying declarations are outside of the scope of its?
It's in a footnote.
No, Your Honor. Crawford left that question open. It
No,
said that historically, dying declarations were admissible common law, but we're not going to decide that here.
Yeah.
It says if they are, they're sui generis, but we're not going to decide that. They're left open.
So all we got then is some state courts that have held.
I have found only one federal court that I cite in the brief, United States v. Jordan, that has addressed the issue of dying declarations. It held they would violate Crawford, they would violate the Sixth Amendment.
But some state courts have held otherwise, at least according to his brief.
That may be. I did not.
But one federal case says it's a Crawford problem.
Yes. Jordan involved the stabbing death of an inmate who, while being given medical help and taken to the hospital, named the defendant. The court held it was dying declaration, but clearly violated the logic and the purpose of Crawford and the Sixth Amendment. As I was saying, David's made that distinction between a past event and an ongoing event. Who was your assailant is not necessary to resolve an ongoing event. It is an accusation of criminal activity by the declarant against a particular individual.
Yeah, that's what worries me about the second statement. Maybe the Commonwealth can answer this. Putting the first one, the 911 call, seems to me to be clearly non-testimonial, but I know you argue otherwise. But that second one is testimonial. Here I am bleeding to death, and Ray Nesbitt, I think she used his name, did this to me.
That's correct. And the point is that it's the same statement. It's the same statement made in response to a question from the 911 operator for purpose of prosecution. Who is your assailant?
Oh, do you think at that point, and first of all, it's, who do we look at it from? Don't we look at it from the declarant's position?
That's correct.
Do you think the declarant, having been stabbed, I feel it was 22 or 23 times, was thinking about prosecution right then?
It's what a reasonable person in position of the declarant knew or should have known, according
Let me tell you, I
Romer.
think you're going to lose on that one.
Should have known.
Should have known.
She's answering a question. She's called 911.
That's correct.
I mean, she's trying to get help.
She is trying to get help.
She's not thinking about what's going to happen after she gets help.
I would agree, and she was not calling them to identify anyone at that point. The identification came in response to interrogation by the 911 operator.
But they have to make some kinds of inquiry. You know, is your cat caught in a tree? You know, come help me. Is your cat caught in a tree? No, I'm here dying. Well, what happened? Ralph stabbed me. I mean, and is he still there? They have to make some determinations as to whether to send an ambulance only or send police with the ambulance to protect the ambulance and protect perhaps the victim from somebody who's still in the house.
Well, they knew at this point that she had been attacked by someone.
But, excuse me, Mr. Graham, surely what the 911 operator is doing, she makes a statement, and the 911 operator can't hear what she said. So the 911 operator, in essence, says who? I mean, not because the 911 operator is thinking about who's going to be subsequently charged. The 911 operator is trying to find out what she said. She's just said something incomprehensible.
Yes, but he calmed her down and he said, "What's your address?" She gave him her address. Who came into your house who attacked you? That's not necessary for medical help or assistance. That's necessary to record that for future prosecution. And that's the purpose. Again, it's the same statement that's made to Mr. McCure a few minutes later when he asked, "Who's your assailant?" Mr. Nesbitt. It's the same question made for the same purpose, the same answer, again, and anybody in that position would know when you identify a criminal suspect, any person would know that's going to be used for prosecution, as the court held in United States v. Pugh, cited by this court in Commonwealth v. Gonzalez.
But how do you know that? She's asking for help. She could have fallen from a ladder and asked for help, and they're just trying to sort out what's the nature of the problem for purposes of a medical response.
But the name of the assailant is not necessary to give medical help. If he had asked, "What's wrong with you? What happened to you? Do you need assistance?" which he only asked after he asked the name of the assailant.
Mr. Graham,
Those questions, Your Honor, clearly are appropriate.
Mr.
But when
Graham,
you
aren't
move
we-
from that into asking for an identification of an assailant,
Mr. Graham,
that-
aren't we
I'm
just,
sorry.
911 calls, aren't we passing these, I mean, you know, we can sit here and we've got minutes, and you no doubt had hours, and everybody had, the jury heard it all. I mean, we are passing and slicing and dicing 911 calls to say, well, it really wasn't to try to assist her, it was to, the 911 operator had in his or her mind, who are we going to prosecute? I mean, it seems to me that that's a very, it's a way of asking 911 operators who are desperately trying to find out what assistance is needed, as Justice been alluded to.
Your Honor, I think I would not argue, and I don't think anyone would argue, that the 911 operator shouldn't ask a whole variety of questions to provide whatever assistance the individual needs. The problem is which of those questions, which of those statements are going to be admitted into evidence against an accused who does not have the opportunity to cross-examine and confront his accuser. That's the
But
question.
because, anyway.
It's a Sixth Amendment issue. It's not what kind of assistance you need or to put restrictions on a 911 operator. The question is, when you get to trial, did the defendant have a Sixth Amendment right or opportunity to confront his accuser? Because this is an accusation of a criminal act. The Sixth Amendment says you have a right to confront your accuser. So what we do need to parse the 911 call, and we do need to say which of those statements can be admitted against someone and which of them should not. We're talking about not just Mr. Nesbitt, but the lives of a number of individuals who may be rightfully or wrongfully accused of a crime, but the Sixth Amendment says you have the right to confront your accuser. So I think we are parsing those calls, but I think the Sixth Amendment says we have to parse those calls.
Do you know where, I mean, there's been a fair amount of jurisprudence around 911 calls. Do you know of any case where a defendant's identity has been admitted? I'll ask the Commonwealth the same
Has
thing.
been or not been?
Has been admitted.
In Davis v. Washington, there were two calls. In one case, the identity was admitted, and the other it was not. In United States v. Arnold, there was a 911 call, which was not admitted. That did involve dying declarations. The problem we have is the problem Justice Graney brought up a moment ago. This involves a dying declaration. In all other 911 calls, when you identify a particular suspect, you come into court and say he did it. The defendant has the opportunity to cross-examine that person. With a dying declaration, the defendant is permanently deprived of the opportunity for confrontation and cross-examination. That's what makes it different.
And that has been the state, for hundreds of years at common law.
That was apparently the position at common law. However,
And the right of confrontation comes from common law. The right to confront witnesses also comes from common law. Somehow they lived side by side
well,
at
there's
the
a
time our
troubled,
Constitution was
there's,
written.
quite frankly, there's a troubled history. And the commentators have not been kind to dying declarations for a variety of reasons. And I'll address those now. First, almost all commentators admit they're not reliable. There is no inherent reliability of a dying declaration. The circumstances in which they're made are often confused, violent, emotional. The opportunity to perceive and to recall facts is compromised. Often,
But reliability is not the test, is it?
it's not. But if
For Sixth Amendment
for
purposes.
Sixth Amendment purposes, reliability is not the test. For common law purposes, it was. But they were generally admitted not to be reliable, which is why they were not admitted in any case, except a homicide case where the defendant was
It's
charged
usually
with...
it's usually the only time you have a dying. It's often the only time you have a dying declaration is when the person dies. That's actually one of
That's
the
true. But
qualifications.
you can have dying declarations in a whole variety of cases involving a whole variety of instances, and a number of those were at common law
I see
prior
what
to
you
the beginning of the 19th century, that they used dying declarations even in some civil cases.
Mm-hmm.
That was later restricted to just homicide cases,
Gotcha.
which makes no sense since reliability is lower and the stakes are higher in a homicide case. In United States v. Jordan, it points out dying declarations simply are not reliable. And that's particularly true in this case, because often the person making the dying declaration may well be mistaken as to the identity of the assailant. In this case, there is no evidence in this record that the victim had ever seen Mr. Nesbitt prior to that night, so as to be able to identify him. We don't know if she could pick him out from a crowd. There's no evidence.
You mean there's no evidence that they had a relationship?
No.
I thought that, I thought that Ms. Levinson testified that the defendant told Robinson that the victim was learning there.
There is no doubt that the Commonwealth filled the record with motive evidence, that the defendant blamed the victim for the breakup of his relationship with Ms. Robinson. There's motive evidence throughout. What evidence there is not is evidence that she had ever seen him. The closest the Commonwealth ever got to that was a birthday party he supposedly attended with Ms. Robinson at the victim's house. That came in through the husband. But when you look at that at volume 3, I think, page 123, The prosecution's questioning is very close and very precise. They never asked the husband if the wife was present. They never asked the husband how long Mr. Nesbitt was there. They never asked the husband, have there been any interaction between Mr. Nesbitt and the wife? That is, on this record, there is nothing that would say that this victim had ever seen Mr. Nesbitt.
All right, let's think of it this way. You've got a confrontation clause problem. That's Crawford. Assuming that dying declarations were admissible at common law, and we conclude that the confrontation clause, as written, anticipates their admissibility, then you get to reliability, I suppose. It's also an excited utterance, so that's also an area that we have deemed to be reliable for purposes of admissibility. So you get over the confrontation clause because it's a dying declaration, and the judge found it was also an excited utterance that was reliable.
Crawford, in fact, held excited utterances would not have been admissible at common law.
I understand that, but
we
it's
still have-
admissible as a dying declaration. It gets by the confrontation clause because it's a dying declaration. Then you also look to see, well, the question you raised, well, are dying declarations really all that reliable? That's a different test.
That's
You
correct.
got over the confrontation clause, you look at reliability. The judge also concluded that this was an excited utterance, which we have also concluded is reliable evidence.
However, it's not admissible under the Sixth Amendment. So you still have the Sixth Amendment issue with regard to spontaneous utterances.
I must be completely misasking this question because I'm saying as a dying declaration, it's already gotten over the Sixth Amendment confrontation clause issue.
That's only for dying declarations. You still have a Sixth Amendment issue for spontaneous utterances. That is, it may be admissible.
It's a dying declaration which has increased reliability because it's an excited utterance. How about that formulation? Would you agree with me on that?
No, I would not, since
Okay.
that confuses the hearsay exception for spontaneous utterances, which have been ruled not admissible under Crawford. And you have a hearsay declaration or exception for dying declarations, which Crawford left open. They're different issues, and the reliability of each have to be analyzed differently and have been. And spontaneous or excited utterances have been held inadmissible under Crawford, under United States v. Arnold.
Well,
So-
in some subsequent case, if in some subsequent case, the U.S. Supreme Court says dying declarations have the same problem that we talked about in Crawford, then they're no good either,
That's
right?
correct.
Mr. Graham, could I ask you to address the fact that the defendant, when he was first came into contact with the police, that there was blood on his sweatshirt that turned out to be the DNA from the victim?
Yes, there was a small,
Was there
very
any
small
challenge to
spot
that?
of blood on the top of a hooded sweatshirt.
And do you challenge that that was the victim's DNA?
There was no challenge to that at court. I think that
So let us assume that you may be correct. I take it there was an objection to the 911 call, at least
That's
parts
correct.
of the 911 call.
yes, Your Honor.
How do you deal with the DNA evidence?
The way defense counsel dealt with it at trial is probably the best way he could. That he claimed that it could have gotten on there through the police who had contact with the scene, then contact with Mr. Nesbitt, particularly because this was an extremely bloody scene. There would have been blood everywhere. Mr. Nesbitt had the same clothes on. He slept out that night in the open, and he had one tiny spot of blood. Defense counsel's argument was, had he done the murder, he would have had blood all over him. But that
So you're
one
saying
spot
it
could
cannot
have been-
possibly be harmless beyond a reasonable doubt?
That's correct. And if I may just quickly address the Matthews case, because that affects the DNA evidence. Mr. Nesbitt would assert quickly that Matthews was wrongly decided for two reasons. If you address a Bowdoin context in which that case was decided, there was none here. So inconclusive results should not have been admitted here. But you could address that through jury instructions, instructing the jury why they're admitted and no inference can be drawn. That's what should have been done in Matthews. Secondly, Matthews reflects a conceptual confusion, respectfully. It confuses an empirical question. That is, does the science of DNA yield valid results? with a logical question. That is, are inconclusive results relevant? Those are different kinds of questions. This court decided not to follow Kernan's statement that inconclusive results are inadmissible due to advances in the science of DNA since 1991. That, again, confuses an empirical with a conceptual or logical question. Advances in DNA will never and can never affect the logical question of whether inconclusive DNA results are relevant. There are different types of questions, and you could have the best DNA evidence in the world and will not affect the relevance of inconclusive DNA evidence.
Thank you, Mr. Graham.
Thank you.
Mr. Souza?
Good morning to the panel. My name is Craig Souza. I'm an assistant district attorney out of Bristol County. I represent the Commonwealth appellee in this matter.
Well, on the 911 call, there's two types of bad Crawford evidence. The first is testimonial as matter of law per se, and that's clearly not that. You know, that would be depositions and that kind of stuff. The second is, would a reasonably objective person think they are giving a statement that would end up being used in court? There's no way you could look at this 911 call and say that that's the case, is there?
Well, I would respectfully disagree. The reason why
I'm
is...
agreeing with you. Why would you disagree with what I'm saying?
I'm sorry, then I must not have understood
Well,
the
that no
question.
person in Mrs. Brawl's, Miss or Mrs. Brawl's position would ever have thought that she was giving testimony in that call that might be used in court.
I'm sorry, I misunderstood your question. I agree with Your Honor.
I mean, it's a panic call by a woman in terrible distress who's been stabbed 23 times and is bleeding to death.
Correct. The evidence speaks for itself.
Can I ask you a question about the DNA evidence, which I don't think speaks for itself? Why should we permit the use of inconclusive DNA results, such as here?
Well, what this court, I believe understandably in Matthews had said is if the DNA test results are inconclusive and the defense counsel in the case brings up the fact that there are, certain situations, in this case it was the blood found on the handlebars of a bicycle, and whether that evidence, that blood evidence came back as inconclusive, whether the defense counsel used that as a sound tactical decision to highlight the fact that it was inconclusive.
Well, isn't that the real issue here? The results were inconclusive on the bike handlebars.
Correct.
But this defense counsel made no objection to the admission of the testimony. Decided instead in cross-examination, based on what I read in your brief, to point out that it was inconclusive.
I would agree with that.
That's a little bit different than the other problem we're talking about.
And that's really identical to Matthews.
Correct.
There was no objection to it, and the defense counsel made use of it as part of the defense.
Correct, and I would further argue to that was part of this tactical decision. And actually, the amount of testimony that came out from the DNA analyst Bogosian, there was an exchange between defense counsel and the DNA analyst, and suggesting that the fact that even the DNA analyst herself couldn't be excluded as the donor of the bloodstain evidence, further highlighting the fact that, highlighting the fact that he had been using this as a tactical decision, because and I don't want to engage in speculation, but maybe because he thought that if he would show that there are inconclusive results, that the Commonwealth wouldn't be able to connect the defendant with the bicycle that was found, I believe, a quarter of a mile from the scene. And if the Commonwealth can't produce that evidence, calling into question the investigation in some way, like in Matthews, then the Commonwealth should therefore be able to at least paint the picture of what it did in its investigatory process.
Well, I mean, if there's a challenge to the adequacy of the investigation, whether or not all of the tests that should have been done were done, then that may be another basis upon which it might be affirmatively offered. Was that this case?
No.
Yeah, I would, the way I would read Matthews is not to say that we're going to narrow it down to where defense counsel is going to unanimously say that the Commonwealth's entire investigation of this case was muddled. It was, they made numerous mistakes in their investigation and gathering the evidence. I don't think that, and I'm reading this court's Matthews decision. I don't read that as saying that specifically the defendant has to challenge all of the evidence, the DNA evidence, or the investigation itself. What we do have here is somewhat of a challenge to the investigation, claiming that, well, you had this blood evidence, and you couldn't connect the defendant to that blood evidence. Therefore, it would have been harder for the Commonwealth to prove its case.
The whole thing couldn't have caused the likelihood of a miscarriage of justice because the evidence against this person is overwhelming, assuming we accept the 911 call.
Correct. And they had
and the DNA on the sweatshirt.
Correct. You had the
which was
DNA on the defendant's.
2.73.6 quadrillion to 1.
And that was the blood. Yes, correct. That was the blood state evidence found on the defendant's sweatshirt. My brother.
Mr. Sousa, could I just go back to the other the
Sure.
bicycle handlebar evidence? It's one thing for the Commonwealth, and I take it Kelly Bogosian as your witness.
Yes, it was
Okay.
the DNA analyst.
I take it that there's no problem, assuming that you've got some challenge, to say. NR, no results, no results, no results. In other words, the DNA is deteriorated, and so we can't get any results.
Specifically the handlebars, yes.
No, I'm just saying that it seems to me that testimony, I'm not talking about this case in particular, but that testimony is, yes, there were other blood spatters. We knew they were blood, but for whatever reason, the outcome of the testing was no results. That seems to me to be somewhat different, in fact, quite a bit different from going on to say, I was not able to exclude the defendant. Because that leaves open the possibility that could have been the defendant. And if you have no results, there are no results.
But it wasn't my reading of the transcript. It wasn't that wasn't the sole basis for excluding it, to say that, the defendant could have been a donor to this sample.
Yeah, but if
It
you
was
have
also further elaborated that neither could the defense counsel in
Yeah, but it seemed to me you're talking to a jury, and if you say no results, we have no results. We don't include, we don't exclude. There's just no results. But to then go on to say, I couldn't exclude, well, of course you couldn't exclude. But when you specifically say, I could not exclude the defendant, suggests that if only there hadn't been a deterioration of the sample, likely was the defendant. I mean, no results is simply, that's it.
Again, if that were solely the evidence that was before the jury, I would tend to
I'm
agree
just-
with that. But
I'm not talking about a substantial likelihood of a miscarriage. I'm just talking about whether or not we should permit that kind of testimony.
within the context of a case, I believe, and Matthews talks about this court has talked about, that it's the entirety of the investigation. The jury is trying to evaluate the case based upon the evidence
No, I
that it's
understand that.
received.
I'm focusing on a narrow thing. Assuming that we agree with you that you can permit somebody to say, because there have been some cross-examination or the defendant has anticipated the DNA evidence, to say, yes, we did test. We tested 1, 2, 3, 4, 5, 6 places that appeared to be human blood, and there were no results. Why were there no results? Because DNA, the samples were too small or the DNA deteriorates. End of testimony. As opposed to saying, I couldn't exclude the defendant. If there are no results, you couldn't exclude me, you, or anybody else. There are just no results.
Correct.
So
But
what's the validity of saying, I couldn't exclude the defendant?
that is the statistical basis by which she, as a DNA analyst, was analyzing the particular piece of evidence that she had.
Why should she be permitted to testify to that? It sounds useless. It sounds, in fact, isn't it prejudicial to the defendant?
That was my question originally.
The fact that the blood evidence on the handlebars was prejudicial to the defendant's case.
Not all of it necessarily. The piece that says, I couldn't exclude the defendant, suggests he's in there, I just couldn't conclude that he isn't in there.
Yeah, we didn't get him this time. That's what it sounds like.
Well, I mean, that's the interpretation, that's based on the interpretation, but within the context, again, and I know I'm reiterating this, but within the context of the entirety of the evidence.
No, the issue is, should that evidence be permitted? And I think the answer is no.
Well, I would
And it may not create a substantial likelihood of a miscarriage of justice.
How does it prejudice the Commonwealth to prohibit that particular question and answer?
Well, we had testimony of a bicycle being found a quarter mile from the scene. The jury, as a finder of fact, naturally, and I say this naturally because a lot of times we're trying to decide what particular pieces of evidence should be in front of the jury, and a lot of times questions may arise, and this is trying to get into the mind of the jury a bit, but the questions may arise as to, okay, they brought up this bike, what about this bike? What's the significance, if any, of this bike? What I posit to the court here is that this bike, this testimony of this bike, there's blood on it. The DNA analyst is saying that that anybody could have donated to that sample. Explaining again, an explanation to the jury as to what was the status of this bike and how is it relevant to this case. In order to explain.
Well, you got to tie the bike into the defendant, and that's what you're trying to do with this evidence, right? But I think the point is very well made that if the evidence is so inconclusive, it's really almost spurious because the jury hears the words DNA and lights up like a Christmas tree. This is good stuff. But the testimony is I can't tell who this belonged to. It could have belonged to anybody in the population, more or less.
Again, based solely on an explanative purpose to let the jury know exactly what it is that went on, what exactly this investigation entailed. What were the investigators doing? They found a bike a quarter of a mile away. What was on that bike? There was blood, but we can't include the defendant as the blood.
We can't determine whose blood it was. Why shouldn't it be limited to something like that? We cannot determine whose blood it was.
I guess a play on words. I mean, the way the analyst is analyzing it, they're giving you a ratio of how much possibility there is in the defendant being, or anybody else for that matter.
What was the analyst's testimony on direct exam in response to questions by the prosecutor about whose blood it was? Do you recall?
I think that's what it was.
That it was, she could not exclude either the defendant or
nor
Mr.
could she exclude the victim.
Okay, and the jury takes that as well, And then finally you get to cross-examination, at least the part I read about in your brief, and you find out that this testimony is worthless in terms of tying the defendant into the blood.
Again, I respectfully disagree that it's useless to this jury. I mean, this jury, again, in order to put the full picture in front of the jury.
You can't put in front, I mean, you're simply digging yourself in because you're saying there were no results, you can't draw any inference, and then you're telling me that you're going to ask the jury to draw an inference because that's the only thing the juries are permitted to do, and that's the danger of this.
We're not, but the testimony, it was brought up by the prosecution. It wasn't further elaborated by the prosecution. In fact, in the prosecutor's closing arguments, he specifically said that this is a poor blood evidence. I could be the donor of that blood. Anybody here could be the donor
Well,
of
I
that
had to deal with it at that point.
That goes to show, and that, based upon my reading of the transcript, that what the prosecutor was trying to do was paint the full picture. And I've said this a number of
You were
times.
trying to link, the defendant.
But it goes against the general principle. It's well established that the prosecution cannot, under the rubric of letting the jury know what the investigation was all about, get into evidence in probable inadmissible evidence just because that inadmissible evidence was discovered during the investigation. Anyway. We'll see where it goes. You got plenty of other evidence against this fellow anyway.
Yes, there is that evidence. I would like to bring up the issue of, if I may just a bit touch about the 911 call. I believe it was Justice Greene that had said that clearly the 911 call would be deemed non-testimonial based upon the circumstances of the case. But what I also further heard is that it's a little bit different when the victim is talking to her cousin, what amounted to be minutes later.
Yeah, that's a little more dicey, but it could be construed as she's still seeking help. She's not dead yet.
Correct. I mean,
don't let me die, and so forth.
We're talking about this victim has been stabbed 23 times. Even when the EMTs reach the scene of the crime and they're trying to assess the situation, they even say there's so many stab wounds, there's too many to count. There's blood everywhere, smeared on the door. To suggest that the victim's cousin would happen upon that scene, and in the words of this court in De Oliveira, whether a reasonable person in the declarant's position would anticipate the statements being used against the accused in investigating and prosecuting a crime, in the victim's dire position where she's in this situation, she's dying.
You could possibly answer that question, yes.
To think that, I would respectfully disagree that the victim in this case would be considering prosecution or getting the defendant in trouble, if that's the correct word. It's clear from the testimony that she's dying, and she knows that she's dying. She even goes so further to say, "Don't let me die. I don't want to die."
Aren't we better dealing with both of these as spontaneous utterances and staying away from dying declarations? Otherwise, you may have to book a plane ticket to Washington to straighten it out.
I believe under either circumstance, what we clearly had here was an excited utterance on behalf of the victim in this case. It was spontaneous. Through the testimony,
well, the problem with the spontaneous utterance in this case, and again, the question is how much we pass it, is she is responding to a question. This is a spontaneous utterance. What she is most concerned about is, get me help. That's clear. Get me help.
Clearly.
Don't let me die. He's saying, what happened? Who did this? What happened to you? She's not spontaneously uttering that. I mean, she's responding to a question.
I mean, in a vacuum, taking those questions and looking at it that way as just what these words are saying is not really looking into the situation of the case. Again, the cousin is his relative family member. He's happened upon this scene at 1 o'clock in the morning. The first thing he sees... Of
course, nobody's detracting from the power of what was happening or the pain that the victim was experiencing. But the question is, can you get, under our evidentiary rules, can you get that in evidence?
She had very little time to reflect, to fabricate what had happened to her. What you saw there, or what the transcript shows, is the cousin happening upon the scene and seeing this horrendous, brutal scene, thinking to himself, my God, what has happened? Who did this to you? Those were reflective questions. The reflective responses were, Ralph did this to me. Don't let me die. There's no chance, reasonably, if we take ourselves and put ourselves in that situation, again, not looking at this in a vacuum, there is no way we can say that in either instance there's a possibility of a fabrication, that she's trying to get the defendant in trouble. She's trying to get help. She's trying to save her own life. She knows her situation is dire. It's evident in that tape and listening to the audio of that tape. It's also evident when you specifically look at the words that she's used. She's somewhat incoherent because she's just been brutally stabbed, and she, at the same time, she knows that she's in that desperate situation and she wants help. It's spontaneous. At the same time, there's no possibility for fabrication.
Did anybody testify that they had seen the defendant and the victim together?
I believe there was some testimony and I would be speaking out of turn if I would to say exactly where that testimony came from. There was times where Ralph Nesbitt had actually gone to the victim's house. There was a relationship between the victim and his girlfriend, and at some point in there, he had visited that house before. Actually, the victim's ex-husband was actually in the driveway driving away. I guess he was moving out of the house.
This was evidence before the jury?
I believe so, yes. Again, I would be sort of speaking out of turn as actually how that came about.
But nobody had seen him out to dinner or at a movie or at a sporting event or anything? I mean,
well, based on the evidence that we did have, I think, at least if we didn't have the explicit testimony as that they knew that they had seen each other or I'd gone out to dinner with this person, there was inferences that they had this relationship, that they were best of friends, the victim and the defendant's girlfriend, and that the defendant had said to the victim's to his girlfriend that he thought that the victim was getting in the way of their relationship. So there seems to be, even if there's not explicit testimony to that effect, that there is at least a reasonable inference that there's been enough of a relationship there to show that he did know her and know of her at the time. I see that my time is out. I rest on the remainder of my brief, and I thank the panel this morning.
Thank you, Mr. Souza.